Muigi uhumuritwo na gucoka gukuithio murigo o ucio wauritwo ni igoti ukuwe kwa ihinda ringi ria thiku 45 ciukite.
Good morning everybody.
Ni thutha wa ndudu ya acirithania atatu a igoti nene aria ni David Majanja, Christine Mioli na Lawrence Mugambi, na aria mamurirwo ni mucirithania munene Martha Koome rucini rwa muthenya wa keri o ringi kuroka gwikira igeca itanya ria thirikari ria kungania mabilioni ma mbeca ciri igoti ria waki wa nyũmba cia raithi iria irakwo ni thirikari riria riagathikirwo ni watho wa kigina wa mwaka uyu uria wanjiriirie kurutithio wira mweri-ini wa mugwanja mwaka uyu makiuga igoti riu ritiumbitwo muthingi-ini wa watho.
That an order is granted prohibiting the respondents from collecting, charging or otherwise the charge known as the Affordable Housing Act on the basis of the Section 84.
Andikani na andikwo aria makoragwo na mushara wa mwisho wa mweri nio makoretwo makirengwo gicunje kia 1.5 hari igana kia mbeca ciao igathie kuri kigina giki. Acirithania aya makiuga igoti riu ni rirathutukania Akenya kuona ribatie kurihio andu othe bururi-ini no tiga kundi kamwe ka muingi.
And we find that the introduction of the housing levy amendment to Section 84 lacks a comprehensive legal framework in violation of Article 10, 201, 2010 of the Constitution. That levy against persons in formal employment to the exclusion of other non-formal income earners without justification is discriminatory and irrational and arbitrarily and in violation of Section Articles 27, 201, B1 of the Constitution.
No mawakiri a thirikari magitongorio ni mũmbunge George Murugara giikaro-ini o kiu makahoya igoti ritikambe gukinyaniria itua ria kugiria ungania wa igoti riu na igoti ria igwa thirikari na kurugamia watho wa guteaniria igoti riu thiini wa thiku 45 ciukite, na uguo ni kuga riagarura itua ria kugiria KRA na ministry ya kigina kungania igoti riu ria nyũmba.
An order of stay be and is hereby issued staying the effect of this judgment issued today 28 November 2023 pending the filing of a formal application for conservatory stay and conservatory orders in the Court of Appeal, and these orders of stay shall remain in force until 10th of January 2024.
Acirithania cio atatu ona gukiri uguo maugite watho wa kigina wa mwaka uyu wina icunje iria nyingi irarumirira watho no kuimwe ciagararite watho.
We have no doubt that this court has jurisdiction to grant orders of stay or conservatory orders pending appeal, even when it has declared provisions of law unconstitutional. This is part of the court's power to frame relief, taking into account the circumstances of each case.
The jurisdiction of this court ends where it has stopped. After that, we now have to invoke another jurisdiction, which is the Court of Appeal, to deal with our disagreements with the judgment that has just been rendered.
The decision by the court to grant a stay, especially for 45 days, and on the strength of an application, an oral application, in our view, is highly irregular and unfortunate and takes away what the court has just given in terms of making the right finding.
Cira ũcio wahandirwo ni seneta wa kaunti ya Busia Okia Omtata. Handu-ini ha Inooro TV, njĩtagwo Harun Njoroge wa Maina.